My experience on managed investment schemes, of course, comes from dealing with victims of the collapse of the Sterling Housing Income Trust. And yes, part of it went to the definition of an investor, the definitions of financial advice, but it also went to the definition of a real property right. And they made a submission to that inquiry around saying that there needed to be a clearer definition of property ownership and whether you were, in purporting to sell a property right, you were actually selling a property right or not. And in this case, it was a lease for life, which had implications across state tenancy law. But when I think about managed investment schemes, there's a whole, there's lots of accommodation and housing within it. And I wanted to, whether it's shared holiday properties, and I'm not particularly clear about the foundation on which the property right inside that is defined and the extent to which it can and should be more specific so that people know whether they own real property or not. Is that something you've looked at all, or would you look at it as part of the review, or do you think Treasury's across it?
Just stepping back, the managed investment scheme framework that we have under the Corporations Act at the moment is really at large. It's intended to attract investment to a whole range of potential investment schemes. And once you meet the statutory criteria, then which are fairly liberal in Australia, then the scheme can be registered. In Sterling, I think one of the things we can take from Sterling is that there was a very complex arrangement, and that ended up attracting the very issues that Senator, you've mentioned. You have this conflation of state and federal law, and the product, the investment that was being promoted through that scheme, in order for people's rights to be fully understood and enforced, involved state property law and as well. But I think the key thing to appreciate with managed investment schemes in Australia is that the policy setting is to encourage investment in a whole range of activities, and provided the basic statutory tests are met, a managed investment scheme will be registered. And I think the other issue coming out of Sterling is that some schemes are going to be much riskier than others, and consequently again, another learning from Sterling was the disclosure that investors or consumers get, and whether they understand that, what they're investing in, which brings us all the way back to the comments that Commissioner Kirkland made about making sure we have the policy setting right, that we want to encourage investment, we want to encourage innovation, we want Australians to invest and take risk, but to do that in a fully informed and disclosed environment. And secondly, paying real respect to this retail-wholesale distinction, where there are some investments that I think we can all agree we want to be really careful about making sure the protections for retail are there. So that's, to my mind, the high-level approach. I don't know whether Commissioner O'Rourke or Kirk want to add to that. But my understanding is that sorry, just to complete that, the Treasury work is ongoing, I think. That's correct?
That's correct, yes.
And so that issue is a way to go. And the wholesale retail test, which has sort of been lurking for years, it's been an issue, I think, that the successive governments and regulators have been grappling with since 2001. That is a subject, I think, of a separate inquiry.
Yes.
So that we'll need to see what comes out of that inquiry as well. I think there's we've made submissions to that inquiry as well.
If you could inform me of what that one is, I'd like to know.
It's one that we've got on the books, Senator Pratt, so you'll get a deep dive as we commence that.
Oh, good.
Yeah.
Yeah, I think from ASIC's perspective, these are really important questions, and we really welcome these inquiries because there's some very significant issues, I think, for investors and consumers, depending where we land.
Can I ask one question?
So if you...
Senator Pratt, can I just ask a
issues...
clarifying question here before
yes.
we jump off? In previous hearings, we spoke about, in the context of Nuix, the very significant difference between the US and Australia with regard to a product and the scrutiny under which a scheme might be advanced in the US by comparison to what we do. With these managed investment schemes, you've talked about the full breadth of, quite simple products that could be low risk to perhaps one of the most complicated, convoluted and deceptive versions that we saw in the case of Sterling. Has there ever been any consideration, and are you aware of any jurisdiction that has a ratings system that would be able to indicate to a consumer, sophisticated or otherwise, this is a green light product, it's pretty clear and easy and it's telling us what it's going to do. This one requires an intersection of state and federal law. There is some uncertainty about the status of the property rights and ownership. Red light and somewhere in the middle, amber. Is that the kind of work that ASIC could be impelled to undertake because it's an evaluative process, but clearly it's a preventative process as well?
Yeah, well, a couple of points. That very issue that Senator O'Neill you've raised was the subject of some evidence during the Sterling inquiry, and the idea of managed investment schemes is not a bad example of where you could have such a system where consumers or investors could be given some indication of where the risk is in that investment. For such a framework or approach to be adopted in Australia, I think that would require amendment to the Corporations Act. And secondly, we'd have to think through about how you'd administer that.
Yep.
So who would decide, and by what process would you decide that something's a higher risk investment or a lower risk investment? The Sterling inquiry did hear evidence from a former chair of ASIC on that very point, and there may very well be some value and upside in helping consumers in that way. But the starting point is, I think that will require an amendment to the Corporations Act. And there's another reason for that. We're the regulator. Our job is to obviously administer the law as it is, but certainly it's not our job to sort of say to investors or consumers, oh, that's a low-risk investment or that's a high-risk investment, or to... our role is to make sure that there's full disclosure and that our laws are complied with in terms of explaining to investors what they're getting themselves into. But we can't, it's not our job, so to speak, to sort of warn people off. Having said that, I have taken the opportunity to warn people off on crypto.
Yeah, there is. And there's not much difference between explaining the risk and identifying in a way that people can understand that's less wordy
I think that's right.
more
I think
indicative in a visually literate age. So I was unhappily unable to attend much of the inquiry that Senator Pratt really pushed with regard to Sterling.
Yeah.
So I need to go back and have a look over that. But can I just signal interest? And if I can ask you to take on notice consideration about similar entities to yourself, or indeed alternative entities within the Treasury finance structure in other jurisdictions that might approximate something that gives a bit of risk weighting in an easily digestible way for people with regard to
I think that last
schemes.
point you made about, given that modern media and technology and systems of communication, there are opportunities for explaining to consumers and investors risk in more innovative ways than might have been the case, historically. Risk ratings where we're actually saying to consumers, we want you to rely on these ratings, I think that would require some reform. But I think Commissioner O'Rourke.
Thank you.
I was just going to
Commissioner O'Rourke, and then I'll come back to you, Senator Pratt.
I was just going to draw the committee's attention to the related sort of underpinnings of the design and distribution obligation regime, which really is designed, it puts on the issuer of the product to say, well, for whom is this product suitable? Like that's that whole idea of target market determination. And for very high risk products, we would anticipate that the target market would be very small, whereas for lower risk products, it's a much wider group of people for whom it might be an appropriate product. So it's a different lens than an external party risk rating a product, but it comes from a similar driver of recognising that there are some products for whom, that it's going to be a very narrow group of people for whom it's an appropriate product. So we do have an element of that in our system, and we've been using that, as you've heard earlier, in relation to the Coral Coast. And I think even just drawing back the connection to Commissioner Kirkland's comments about in relation to better banking products, again, our effort has been to push to the issuers, in that case the banks. What are they doing to do the right thing? And I think the design and distribution obligation similarly puts on the issuers of financial products of any kind that question of determining who the right people they're selling their products to.
And it doesn't currently impose on them a self-assessment of how risky this is. They don't actually have to state that, do they?
It's not a risk rating in a red, orange, green sort of traffic light, but I think by having to identify a target market and then describe it and then have set systems in place to only sell, to have those distribution restrictions in place in order to ensure that the product goes to those people in the target market, it's not the same, but
there's a front loading of protection in that structure. I understand exactly what you're saying, and that's perhaps somewhere to start. But thank you very much. Back to you, Senator Pratt.
Thank you. That was a question along similar lines that I had, but I've got a further question, again, that returns to real property rights, which I understand are an issue for the states. Do you have much of a picture? Like state parliaments and governments have to review property rights all the time, but they do so with a different frame, not with the same kind of frame as ASIC, trying to encourage investment, but then regulate bad products. They're the ones that have to actually determine the nature of that property right. Are there more things that we can do to push the states then to have a better look at this in the context of how these property rights get turned into investments? They do when they do review them, but they seem to do it with a bit of a different lens because they've got different legal and constitutional levers.
You want to have a go at that?
It's not something I don't think it's an issue we've really turned our mind to, and obviously
that's fair enough.
a complex one, just given the range of jurisdictions and the constitutional issues you sometimes come across as well. I would say on the property issue, there are some different approaches internationally to managing that risk of investment in property via the equivalent of managed investment schemes. So, for example, in the UK, investment in real property is prohibited through those types of managed funds. So they've at some point in time taken the call, for retail investors that is, it seems that at some point in time in the UK they've decided that the risks of retail investors investing in real property via managed schemes are too high. So there are other policy levers like that, like restricting the types of assets that funds can invest in that can also provide additional protection.
Yeah, but you could, if you wanted to share a holiday house, that would be fine, but you wouldn't, and co-own it, but you couldn't sell it as a managed investment scheme in that context. Or if you wanted a shared tenancy, like, at which point do we call this an investment in which you're going to guarantee some kind of return versus essentially saying, look, you can put your money in these places, but you can't you can't accept the advice that you're going to get, in the case of Sterling, all your money back at the end of the day, which is essentially the advice that they provided.
The fundamental difference, I guess, is between, I guess, something like having a shared investment property and investment in property via a managed investment scheme is really whether your name is on the title. So if you buy a property as a tenant in common or joint tenant, then you actually have an interest in that property that is recognised. And so if it's sold, you would be entitled to the comparable interest from the proceeds of sale. With a managed investment scheme, you have an interest in the fund, but it's the fund that owns the interest in the property, and there's no direct line of ownership from the individual investor through to that particular property. And that's why these are inherently more risky.
Well, I think this is a really important point, because the victims of Sterling were told, in effect, that they had a real interest in the property and that was via their guaranteed lease for life. And they were nowhere on the title, and, you know, they had a so-called 5-year lease. But we all know that if a property goes, if the homeowner can't pay their mortgage repayments, then you can evict someone. And so there was very much a breach in that case of what would now be design and distribution obligations, because, frankly, their understanding of what their property right was did not match reality at all. And I think, Commissioner Kirkland, you've explained it so simply and clearly about, well, you're not on the title, and therefore you can't consider. I think to that end, we need to be really clear that people don't misunderstand that they don't actually have a property right if they're part of a managed investment scheme that owns the fund, and they don't own, in effect, the property. So I think there's a need for much greater literacy among some investors about that fact, and perhaps that is something you could go away and highlight in your oversight of managed investment schemes.
We are
because you've explained it very succinctly.
Thank you. We are concerned in general about property investment schemes, but there is a particular risk of consumers being misled where there is a suggestion that they have an interest in a particular property through that scheme. We are planning on saying more about property investment schemes in the coming months as a result of some work that we're doing. So we can take on board that suggestion that we think about how we really convey some of those particular risks better to consumers.
Yes.
Thank you. That was really, really useful.
It would be good to say what you just said.
Thank you.
That
was pretty clear. So, yeah. But also, you will never own a property. You will only have an investment that will return money. You will never own property. It's kind of a pretty clear statement too. And this is the conversation
may or may not return money.
Yeah, exactly. And this is the conversation in other inquiries that we've taken, evidence with regard to professionalism and, you know, operating in the market with integrity rather than fluffing the words out to the point that you've got a product that is profoundly deceptive in every normal ethical person's understanding of the word, but it's a great product to sell to rip off a whole lot of people. I mean, and sadly there are malign actors who can and have proven that they can manage their way through the managed investment scheme hoops and create such a product as we saw. Now, we have Senator Scarr wants to ask some questions about this, and I note that Senator Scarr chaired the inquiry into Sterling, so we're particularly focused on that. And just before we jump to those questions from you, Senator Scarr, I think Ms Court, as Commissioner Court, wants to make a contribution.
I do, Senator O'Neill, and it was remiss of me not to do so earlier. Just given Senator Pratt's interest in the urban rampage matter. I should have jumped in before we moved on from that topic so quickly. I just wanted to draw the committee's attention to some of the work that went into achieving this recent AAT outcome.
Can I stop you there for a second?
Yes, I can.
Because thematically we're in a different place. I'll come back to you as soon as we finish the
That's
MIS
fine,
bit.
Senator O'Neill, thank you.
Because Senator Scarr has indicated.
Grateful for that.
Yeah. So Senator Scarr's going to do something on Sterling now, and then I'll return to you again, Senator Pratt. So Senator Scarr on Sterling.
Thank you, Chair. And I'm sorry I apologise to the witnesses. I can't be on video today. The technology is somewhat problematic. I wanted to follow up some questions on Sterling. And first, as I always do before I talk about Sterling, I again want to place on the record my congratulations, Senator Pratt, for pursuing that interest and continuing to pursue the interests of the investors, tenants, who were absolutely, in many ways, destroyed financially by that appalling managed investment scheme. We've been talking about investment in property, but it's right, isn't it, to say that the Sterling managed investment scheme was even more problematic because it was people's right to live in their own personal home that was caught up in the investment. So it's one thing to invest in a scheme where you're investing in a property which is occupied, say, by a third party and doesn't compromise your own living arrangements, but it's another thing entirely to have a managed investment scheme where your own right to live where you're living is potentially compromised if the investment fails. That's correct, isn't it?
It's Joe Longo, Senator Scarr, trying to remember all of the detail of that inquiry. The enduring theme for me coming out of Sterling was the complexity of the arrangements and the powerful marketing that went along with them. So these mostly elderly people, it's quite shocking, were sold a dream. They were sold being able to live in their own home without owning it, according to a very complex leasing arrangement, which met the basic requirements of a managed investment scheme, but which, as I think has been acknowledged again this morning, it really wasn't understood by those who were investing at the time what they were really investing in, and the how can I put it, the weak foundations of what they were investing in. So I think the only other point I would add to what's already been said this morning, which I think is something we've done differently, is tried to work more closely with state consumer affairs departments and organisations at state level. So we've increased our engagement at that level around the country and certainly in Western Australia to ensure that we can share intelligence and information about what was going on. Because another lesson from Sterling was that there were issues raised, of course, with the Western Australian consumer protection authorities through complaints rising out of residential tenancies and issues of that nature. So, I don't know whether that answers your question, Senator Scarr, but.
Well, I was just trying to. You've actually answered my next question to some extent, but I was just trying to draw a distinction between an investment where you're investing in a property scheme which doesn't involve your own personal place of residence, as opposed to investing in an investment scheme which includes your personal place of residence. And if you sell your family home, put the proceeds into a managed investment scheme, then enter into long-term residential tenancies, which are all part and parcel of the managed investment scheme, you're far more vulnerable if everything comes crashing down, as it did in Sterling. I guess that was the point I was making.
Yeah, I couldn't agree with you more. it was such a high risk investment for the very reason you've touched on. It's one thing, if I may say so, to invest in property and you say, okay, that's the asset class I want to invest in, I want exposure to that. It's quite another thing to put your family home on the line, which is the very distinction that you've very powerfully drawn out, Senator, with respect.
So in terms of that, and by way of introduction to my next question, certainly I was very critical of the WA government in relation to its response in relation to this scheme. I thought they should have been on the front foot much sooner in terms of raising red flags in relation to the scheme, because the whole notion of having almost life residential tenancies raised all sorts of red flags, should have raised all sorts of red flags in that context. To what degree you did mention, Chair, that you're having discussions with the state agencies and consumer protection. What form do those discussions take? Has there been a round table in relation to these potential schemes, these sorts of schemes? Any protocols agreed with different states as to what to look out for? Who should be raising a red flag when, if they get any intelligence in relation to these schemes? And I ask these questions simply to ascertain what comfort we can obtain as a committee as to what would happen if one of these sorts of schemes raised its head again.
Yeah, that's a really tough question, Senator. I think where I was heading with my earlier remarks, and I think one of the learnings from Sterling is that we're the Financial Services Consumer Protector federally, and one of the things I think we're doing a lot more of now is engaging more systematically with local consumer protection, I'll say departments at state level. And we're certainly seeing that in New South Wales in a different context, which I can come to if it gets raised. However, I think the premise of your question is quite ambitious, if I may say so. I think that the level of cooperation and collaboration is really intelligence sharing, and having the relationships and having that engagement. I couldn't say right now how often it happens, but I think it's certainly more frequent than it was 3 years ago. It's quite another matter, I think, to say, oh, well, we're aware of all these some schemes that are out there. We don't monitor them, we don't supervise them, and so unless issues are brought to our attention, either by members of the public, investors, or by state departments, we don't generally proactively go sort of supervise, monitor the performance of these schemes. And as I think as Commissioner Kirkland said earlier, the other interesting thing about these schemes, which I really hope we can address through these inquiries, is data. We need to know how many there are. I think a better data, I think, would help us be more proactive in this area.
But could I ask a supplementary question, Senator Scarr, on this, which is your question again goes back to why the Sterling victims raised the issue of real property rights inside the context of the review, but it might even help to formalise more specifically those disclosures in product disclosure statements, etc., about the nature of any purported real property right, or even just to highlight the need in the context. They might not get what they've asked for in terms of definitions of real property rights, but it could, in fact, at the very least, bring the onus back on the context of the review to the very strong need for ASIC as oversighting managed investment schemes in a regulatory sense, to have that line of sight back to state regulators in some way and highlight that obligation or that relationship. And I'd be interested in your insights as to how we can put meaning into that work be it just data but perhaps obligations really to make sure someone has done an assessment of that robustness. If it's not your job to assess the investment, perhaps when the question of a real property right does arise, it should be a question for the states, perhaps, to do a more formal assessment of the nature of that right.
I think the most fundamental sort of observation I'd like to make about this sort of interest is that in the end we're talking about investment activity. So a managed investment.
But I think, they didn't consider this an investment. They did not consider this an investment. They considered it a property right. And the state regulators didn't, in effect, gave them assurance about the fact that they had a real property right because they had the lease. So, in effect, if the regulator, if there's no foundation to that property right within an investment, surely there has to be a way of highlighting that to people.
Well, the particular... Do you want to...
Mr Kirkland?
The committee may well wish to examine whether there should be additional protections in relation to managed investment schemes that involve investments in property as part of that other inquiry because of the particular risks that are highlighted. I think one thing we would generally say is that there are real limits to what you can achieve by requiring things to be disclosed in product disclosure statements. I suspect there are managed investment schemes right now that involve investments in property that some of the investors don't fully understand, but where those investments have been properly disclosed in the product disclosure statements, because these schemes are inherently complex, some of them extremely complex, and that's really where the risk comes in for retail investors, that it's, in many cases, it's difficult for an ordinary investor to really get their head around the nature of the investment, the risks, the degree of volatility, whether it's liquid and they're going to be able to get their funds out when they need them.
Yes, but in the state law, it might look like a much more, the veil of how complex it is being hidden by the fact that there looks to be these quite simple that they've bought into these quite simple property rights at a state level when in effect they haven't. And they're attaching the idea of their investment to state property law when in fact it's a much more complicated thing. And the states, if you like, aren't highlighting that fact to them because in effect you've contracted out of your property right.
I think it's really hard.
So it could just be an issue for the states, really, to I guess I'm trying to learn from this conversation to ask the states to put a bit more pressure on them to. So when you've got a lease, you've got all these other conditions and clauses on it, and it's the effectiveness, perhaps, of some of those provisions that don't then reflect the level of risk in the managed investment scheme that are like a caveat to the property rights and leases or whatever you've bought into.
I don't know that ASIC can assist us much further today with that inquiry.
No, that's fine, Chair.
But we might, really on the strength of those comments, end the gap that's clearly remaining, despite the advertising and the awareness people might have post Sterling. That is an issue that we might involve perhaps some invitations to state governments when we come to the sophisticated investor test, that there is an opportunity there, and this is a timely reminder. So I've just had a word with the Secretariat that will prompt us to have that conversation when we return to consideration of the program as a committee. I'm going to go back to Senator Scarr to continue the line of questioning around MIS.
Thank you. And I'll just... with indulgence, Chair, I just want to flush out a few more of those issues which Senator Pratt raised. And I think it is fair to say the PDS after ASIC's input at least in relation to Sterling, you walk through it and you could probably find everything you needed to find, but it was just the level of complexity. I mean, it took me hours to work it all through. And then subsequently you had the Western Australian Supreme Court finding, based under WA retail tenancy legislation, that one of the most important rights was unenforceable. And that's what led to the vulnerability of the residential tenant. So I think the complexity was of the greatest of magnitude, and the downside risks were just devastating. So I think that's why Senator Pratt and I are still agitated, if you like, in relation to the issue, because we don't want to see anyone else go through that again. It was it was diabolical, the consequences for those people. And I met people, including from Queensland, in my own office, who went through the Sterling process. So I don't know if it's possible, Chair Longo, to take on notice what further thoughts ASIC might have in relation to that, in terms of, in particular, I'm interested to know where the enforcement action's up to in relation to some of the individuals involved in Sterling, and whether or not ASIC's investigation is ongoing in relation to Sterling, in relation to any other individuals. Is there any additional information?
Well, Senator, you've anticipated a question I've just asked my deputy to talk about. Charges have been laid against certain individuals arising out of that, as you've put it, awful affair. So I'll hand over to Deputy Chair Court, who has the details.
Senator Scarr, Mr Longo is correct. So 3 individuals have been charged who are connected to the Sterling Income Trust. They're facing numerous criminal charges. So those 3 individuals are Raymond Jones, who was the founder of the Sterling Group, his son, Ryan Jones, and another associated individual, Simon Bell. So they are facing those charges in the Perth Magistrates Court. And probably, Senator Scarr, given that it's a criminal matter before the court, I should probably leave it there. But suffice to say, those charges were laid back in November of last year, and the matters are working their way through the courts.
Okay. Does ASIC have any ongoing investigation in relation to anyone else who may be subject to either criminal charges or perhaps civil proceedings?
No, we don't, Senator. We examine the full range of circumstances surrounding the misconduct in relation to the Sterling Group, and those were the 3 individuals that the investigators concluded should face charges.
Okay, that's fine. Chair, I don't have any other questions in relation to Sterling. Obviously, I've got some questions in particular in relation to the very helpful answers to questions on notice that I was given following our previous hearing, but no more questions on Sterling from me.
Thank you. Just before we close off on that, Senator Pratt, did you have any further comments or questions that you wanted to put on the record with regard to Sterling or managed investment schemes more broadly?
Well, I just wanted to observe from Senator Scarr's comments that separate to the financial return, people were in effect sold a right that wasn't enforceable. And so perhaps that is also something in the context of is someone buying an investment? But if someone is buying something other than an investment, some other kind of right, then we could perhaps look at some of the frameworks around that. When people do routinely buy other rights, like it could be that you get a share in a property that you can stay in over holiday periods, or so there perhaps needs to be a focus on separating out the financial return, and 2, what does it mean to have these other rights attached to a managed personal rights attached to a managed investment scheme. Thank you.
Commissioner Court, did you want to make any comment there, or are you preparing for a different matter?
Senator O'Neill, sorry, Mr Savandra's just alerted me, just in relation to my last answer to Senator Scarr's question as to whether there's anything additional continuing. While we don't have anything continuing in relation to the Sterling group of companies per se, I do understand that we are looking at something in relation to an associated entity, but I don't have the precise details with me, but I can get those for Senator Scarr. But I think it's fair to say the main, as I said earlier, the main focus of those proceedings was, in effect, to hold the individuals behind that scheme to account by the laying of the criminal charges that I referred to.
And can I ask that you provide any further information on notice in a form that can be accessed by the entire committee? That would be helpful. And if you could give an indication of any sense of a timeline on how this matter is likely to proceed, because the committee clearly retains interest in the matter because of the egregious nature of what occurred and the impact on so many people's lives and their fundamental access to a roof over their head. That matters to everybody.